The theory being that although you're not entitled to anything until he or she dies, if he or she is doing something improper with the money, you have the right to require them to go to court and stop doing what they've been doing that's improper. The court can do that by either removing them as the trustee and putting in some new trustee or something along those lines. Unfortunately, these living trusts are often perceived by lawyers as being the boon to the litigation profession because living trusts were enacted to save probate fees.
Right.
Probate fees were statutory fees that the lawyer could pay himself for probating the estate. But with a living trust, there's no mandatory court supervision. You don't have to get court permission to do things. So often people who become the trustees never see a lawyer and take the attitude that this living trust was set up to enable me to avoid lawyers, avoid probate, not pay taxes, not pay creditors, and that's not true.
Right.
Whether you've got a living trust or a will or nothing at all, there's an obligation to pay the creditors of the decedent, pay any taxes that are due and owing, whether they're death taxes, as we call them, estate taxes, or income taxes. But we're seeing more and more of the situation where the surviving spouse, although they didn't get the money outright, it came to them as the trustee of a Q-tip trust, is still not doing what they're supposed to do with it. In fact, they're spending it on themselves, and heaven help us, they often go ahead and leave that money to their next spouse as opposed to the people to whom it was supposed to go,
Right.
the children by the prior marriage.
Oh boy. Okay, so related to what you're just saying then, because of our current social situation again of half the marriages ending in divorce, so many families, second families with adult children and so forth, or children from a previous marriage, that in so many cases at the death, that you basically have an explosive situation waiting to happen.
You do.
Yeah.
And of course, you don't want to basically approach someone at the funeral. That's not the appropriate place. A couple months afterwards, though, people should be prepared to tell you what they should have told you already
Right.
without you having to ask.
Right. All right. Now, I'm the beneficiary of a will or a trust that has a no contest clause. Does that mean that I'm shut out or can't challenge that will or trust? What should I do?
No contest clauses have been with us for a very long time, and they're often misused. The initial idea, or the original idea behind a no contest clause, is that if you wanted to leave something to somebody but you were afraid that they might try to get more, you would put a provision in your will or your trust saying that I've left you this money, but if you attack the will or try to break the trust and you lose, then you don't get that money. No contest. And generally speaking, they're effective. But they're only effective if there are a couple things involved. Well, first of all, a no contest clause in a trust that doesn't leave something to the person that might contest it is useless. They've got nothing to lose. They're not going to lose anything if they file a contest. And also, the effect of the no contest clause, or the threat of it, is directly proportional to how much you got.
Yeah.
If it's a $20 million estate and you were left $10,000, and if there had been no trust or will, you would have gotten half of that $20 million estate. Well, you might decide to put at risk that $10,000 to $20,000 in the hope that of winning the case and getting $10 million. The problems with living trusts is that sometimes the trustee uses them for an illegitimate purpose. For example, the no contest clause was never intended to allow the trustee to misadminister the estate, to loan the money to himself, to spend it on a high standard of living. He's a fiduciary, and he's supposed to hold on to it and administer it for the benefit of the beneficiaries. Right. But sometimes when a beneficiary says, listen, we haven't gotten an accounting in a long period of time, please send us the accounting, sometimes the disreputable trustee will say, well, you're violating the no contest clause. Well, that's not true, but it still could be a threat. So a lot of people don't understand that these threats about no contest clauses often don't play out. In essence, a no contest clause only prevents you from trying to break the trust or the will. A legitimate purpose would be if you had two sons or two children and you decided to leave $900,000 to one and $100,000 to the other, you put a no contest clause in to make the one that got $100,000 think twice about putting that $100,000 at risk to gain another $400,000. But otherwise, if they're used for different purposes than that, you can usually pretty much get around them, or I should say you could defeat those types of claims.
Okay. All right. as a surviving spouse or a child of a decedent, what rights do I have, irrespective of the terms of the decedent's will or trust?
Well, adult children pretty much don't have any rights. If your parents, exactly, your parents' money is theirs to do with as they please. They could have 17 children, but if they want to leave it to the man in the moon, they can do that. The law is very emphatic, it has been that way for a long time, that you don't have to do anything special with your money. You don't have to do what somebody else thinks is reasonable. You can be as, frankly, as arbitrary as you want to be. But the thing is that there are certain people that are protected. Surviving spouses and minor children, for example. If, for example, there is a will, not a trust, but a will, the surviving spouse and the minor child get what is called a family allowance. In other words, it's kind of like post-death spousal support, where they get a certain amount of money necessary to maintain their standard of living until the probate is over. 6 months, 9 months, a year. That they get automatically. They may also be able to get what's called a probate homestead. That means if the house that was the residence, the court can say to the surviving spouse, even though he left his house or his half of the house to somebody else, you have the right to live there for a certain number of years. For example, if you were married to someone for 20 or 30 years, but you left your half of the house to somebody else, that particular spouse could probably get a probate homestead for the rest of her life. The other person who was supposed to inherit the house doesn't get it until he or she dies. So those are the two main things. Now there's one other thing that people should understand, that California and a few other states are what are called community property states. Pretty much what you brought into the marriage, what you inherited during your marriage, is your separate property. But pretty much everything else is community property, your earnings, for example. Most people have a combination of both, but primarily community property. Now your spouse's half of the community property is his or hers to do with as she pleases. You don't have the ability to tell your surviving spouse exactly what they have to do with it. They can go out and blow it if they want. So even though your will or your trust may have left your half of the house, your half of the stocks, your half of the bank accounts to somebody, or tried to leave the surviving spouse's half as well, it wouldn't cover that. You can do what you want to with your own half. There are certain things called forced widows elections, where some men, for example, try to control their widows from the grave, saying, I'm going to leave my half to you, but you have to promise to do this with your half. Some people still do that, but it's becoming very, very, very rare these days.
Okay, I think that's a positive development. Okay. Let's say I do have to go to court related to an inheritance. Can I recover my legal fees?
Generally speaking, not. California, like most of the United States, does not have what we call in England a loser pays system. In California, each person pays their own attorney's fees. There are special statutes and special situations where you may get your attorney's fees, and some of those exist in the probate area. One of the most common is if you have a bad trustee, somebody that is misadministering or what we call defalcating in his administration of the trust, and you petition to remove him, and you were successful. And the court, this is a very important point, also finds that he acted unreasonably or in bad faith. The court can order him to pay your attorney's fees out of his own pocket, but that's relatively rare. A more common way of recovering your attorney's fees is, let's say there are 2 or maybe even 10 beneficiaries. Only one of them files an action against the trustee to compel him to account, and if he discovers that he's misappropriated some money, to make him pay it back. If that beneficiary is successful, he has basically done something called acquiring or preserving a common fund, because the money from the bad trustee goes into the trust and is shared with all 2 or 10 of these beneficiaries, only one of whom had to hire an attorney. In that event, the court will often say to the beneficiary that filed the lawsuit, we're going to award you attorney's fees out of the trust to yourself, because you've conferred a benefit on the other 2 to 10. But keep in mind, in a situation where there's only 2 beneficiaries and you're the one that prosecutes the suit, in effect, what you'll wind up doing is having half of your attorney's fees paid by the beneficiary that was just not doing anything.